Stephen Adams, you talked to him? This was the only time you talked to him this morning?
Yes, you saw the appointment last week.
I love it when people tell me that I strip them of the due process rights that you wrote into it, since I don't even know what you're talking about. I don't even know what you're talking about. You've been appointed counsel, or you've had counsel, now Mr. Nowdy. Before that was John West.
Yes, sir.
And if they fail, then that's their problem that they have to answer to me and the Bar Association, and their license gets risked. And but accusing me of stripping you of due process rights, the most important thing was to have competent counsel. If they are both competent counsel, if they fail for whatever reason.
This is a critical legal moment. The judge is drawing a hard line. Ineffective assistance of counsel is a claim against the lawyer, not the court. But here's the twist. If the court knew or should have known counsel wasn't communicating, that line starts to blur. So the real question becomes, who dropped the ball first?
You don't blame the judge.
Yes, sir.
Okay? That's the way that should be. Mr. Nowdy had been appointed. He's a fine lawyer as well. But you're asking what?
He has indicated to me that he wishes to have his case set for trial and to have it open to meetings.
I don't want to see you. You want to represent yourself?
Yes, sir. I don't trust y'all counsel. My rights have been violated continually over and over again. I've heard requests trying to remove John West from my agency. He didn't give me no evidence and nothing right. I've been sitting in this county over 2 years with medical issues and stuff.
How many times would you say Mr. West came to see you?
He came to see me one time at the jail. I think I didn't really come to see me. He never came to see me at all.
Hold on.
The problem is,
Hold on. How long were you in jail?
I had been in jail for,
Let that sink in. One jail visit in a year. That's not just frustration talking. That's the emotional weight of pretrial detention. For the audience at home, imagine fighting a case you've never even seen. No evidence, no strategy, just time passing. This is where legal theory collides with human reality.
from my youth. 1 year, he came to see me for the first time. He fell asleep up here, but he told me flat like he's going to talk about the age. Yeah, I haven't seen his nothing against me at all. I've been trying to come see you. I got questions here. My dad's called and corporal made requested hearings to get motions. Got called with him and spending it out without denied. I had the right to be present in court. When I get part of the process, confirmation call got it.
That's not what this is. That's not what I don't have to read a lot of articles on the Constitution. And it's not a debate on the Constitution, but
John must have informed that he became aware of a conflict because he's a co-defendant in the case, so that also might be a reason as to why.
when was John West appointed, though?
He's appointed to me in June of 2023.
Let's go, we're going on 2 years. And he's only talked to you one time?
One time,
How did you get appointed?
Yeah, she's been on.
Well, how did, okay, yeah, well, the thing, what is bothering me is why I wasn't told that he had only been, he had only, for 2 years, he's only seen him one time?
There was an issue with co-defendants on, and
Well, I did, but
I'm
But
not sure how.
that doesn't stop somebody from representing. I mean, if they don't see him, they're not representing.
Well, with a co-defendant judge, you can't legally talk to him.
So, yeah, but somebody can walk up to me and tell me about it. You know, if that's a problem with them, y'all, but I mean, he's only been seen one time in 2 years by law. I mean,
This is where alarm bells start ringing. 2 years, one meeting, multiple attorneys listed on paper, but zero communication. On paper, the system worked. In practice, that's a problem. And courts don't like problems that suggest the system itself failed, because those can undo entire cases.
You know, and this makes me as policy.
and nobody's, well,
At some point, I don't even know. At some point,
I don't-
Lewis as his attorney as well.
huh?
He had Marvin Lewis as his attorney.
Did you ever see Marvin Lewis?
No, sir. Never signed.
He's never, that doesn't mean whether you, if you're unable to hire somebody, we don't wait for you to sign. We get you lawyers so that they can talk to you, and they're supposed to communicate.
You know,
If they're not,
talk to me. Sorry.
we can't, we
We can't
draw
draw
a
a shot.
yeah. So, yeah, but it needs to get to me. Nothing's getting to me and being presented to me. But so Marvin Lewis was representing you, and he never called.
Yes, sir.
That didn't happen on my watch normal. So
I've been trying to address the issue just because like this case, it's all happens to me like my trying to prove my innocence, trying to fight my case. Like,
Judge, it looks like Mr. Lewis had his case when he was at the 252nd. It's not how the case ended up over here. I'm not quite sure why. So, for us,
you're in the 257.
they're out in with you this whole time.
No, I don't think so. I think for some reason it started off at a 257, which is probably where a problem began. It never got.
There's 4 co-defendants. We had 3 of them. Probably moved it over to the others. Not sure. I have all 4 let out 2 of them.
How long have you been representing?
two judges.
She's good about it. Yeah.
I do appreciate talking. We can go and
And I did realize that
You want a trial, right?
yes, sir, I do.
She's able to represent you, but you'd probably go to trial if you requested me to appoint somebody off the trial docket wheels.
I just, oh yeah, I'm
You know, all competent lawyers, she would take probably a longer time because she's one of the defenders. And they have a ton of cases that are all lined up for trial.
just don't want to have to go through all the 2 ways. Right, I just forget about myself. I just,
Here's what you're gonna have to do is fill out today, right here before you leave, an indigent form. Yes, I declare you indigent, which I'm sure I will. And I'm gonna appoint a lawyer immediately to represent you for trial. And we will put it on the trial docket, right? Do you understand? I'll fill that out. And that's what you want. Fine.
yes, sir.
Okay. All right.
Yes, sir. I don't want to train those. I don't want any attorney. I just don't trust the counsel. I appreciate
Let me ask you, have you ever represented yourself in trial?
I am, you know, about James being wrong and with these lawyers because I've been done so wrong the last 2 years. And I appreciate y'all concern. I really do. I'm not trying to be the type of way. I just, I really take the chances by myself. I got it.
Do you know how wrong that decision is? It's wrong. I mean, I was
There it is, the most quoted warning in legal history. And it's not arrogance, it's experience. Judges hate self-representation because it turns trials into procedural minefields. Every objection missed, every rule misunderstood. It all stacks the deck against the defendant, even when the judge is trying to be fair.
We practiced law for 45 years, since 1979.
Sir, I appreciate y'all.
Hold on. You speak over me, that's not right. Okay, let me just explain to you. Right. We've done this for 45 years. And it's true. Someone who represents themselves has a fool for a client. That's an old, that was an adage that came up way before I was born. Because it doesn't change. People who are trained in the practice of law are more confident. You are not aware of the rules of evidence. You're going to be held to them. And if you don't follow the rules of evidence, then you are punished in the trial. When I say punished, you're trying to get things done, and if the court says that's not the way it's done, I'm not allowing it, then you lose opportunities to prevail in the trial. You don't need them. You lose battles. And you got the Code of Criminal Procedure. The penal code, you're charged with penal code violations. People went to law school for that. Now, some lawyers, unfortunately, like at every some people, and it's some give everybody else a bad name, but by and large, the people who practice in this court do a fine job. That sounds like it is aberration what has happened. There's no way that you shouldn't have been discussed this and gone over with this. That doesn't mean that the Bar Association has failed you to those hands. And that's just the way it is. You just don't say, I'm sick, I have a bad doctor, I'm not gonna go get fixed, but I have a disease that if I don't get help, I'll die. I'm just gonna die. That doesn't make any sense. A competent, what I'm gonna do is send somebody over to you, you decide after you talk to them first, okay? Because truly, it's something should have been told to me that they never came to talk to you. And here's what we're going to do: is I'm going to have a hearing with those and find out why that happened. And I'm going to ask you to be present, because these are people who work on my behalf when I appoint them. And if they're failing, then they're going to be answerable to this court and the bar association, as well as to you.
I agree with the bar. I ended up hanging the evidence for myself.
That's incredible. I don't understand that nobody who has not discussed evidence against you with anyone in 2 years. That's preposterous. That shouldn't have happened. So, okay. And I'm going to have a hearing on that here. But fill that out. And I will, in fact, I'm going to let her work with you.
This is the turning point. Notice the shift. The judge moves from defensive to corrective. A hearing is ordered. Accountability is back on the table. And discovery is finally acknowledged as missing. For viewers, this is the takeaway. Courtroom justice isn't always clean, but when the right questions get asked, the system can self-correct.